SJC-11348, Commonwealth versus Stanley Donald.
Good morning, Your Honors.
Wait a minute.
Hold on just one moment. We want to get you live on tape, so, all right. Now,
Okay, good morning, Your Honors.
Yes.
My name is Tom Frothingham. I represent Stanley Donald. And Mr. Donald's motion for post-conviction DNA testing pursuant to 278A was denied, and it's the appellant's contention that it was denied in error, both procedurally and substantively. And briefly, I'd like to summarize the judge's ruling. The judge ruled that the motion did not comply with 3B and noted that the DNA testing was done and the results were admitted at trial. That was a response to a letter Mr. Donald had written to the court, and it had no reference to any test in it, and it clearly did not comply with 3B, and Mr. Donald never intended that to be a motion. While that was, I guess, being considered, there was a motion filed that went through the elements of Section 3B, and after the denial of Mr. Donald's letter, which was mistakenly taken as a motion, then the first motion was denied, just citing back to the original denial. And I think it's important that there was no test requested initially. So there's no test under consideration by the court in that first denial. And the Commonwealth makes an argument that the judge's denial with her notation that it didn't comply with 3B and that DNA testing was done was a conclusion under Section 3B.5.1 that the test was not undeveloped at the time of trial. So I would just like to point out that at the first initial ruling on this, there was no test requested. And I think that's important because I don't think in this process of evaluation under 3B, there was ever a consideration of whether the profiler plus co-filer test was different than the DQ alpha test that was used at trial.
It was first denied, it didn't comply with 3B, then there was a motion for reconsideration?
No, Mr. Donald had written a letter to the court. I didn't know about that or just wasn't paying attention to it, and I filed a motion on March 15th. He had written a letter shortly before 278A had been enacted. He had written regarding Senate Bill 753. So the court got that letter, then I filed my motion. Then the court said, taking his letter as a motion, denied it for failure to comply with 3B, and DNA testing had already been done. Then the court ruled on my motion and said, referred to the April 4th, 2012 ruling on Mr. Donald's letter. No more, just said denied under.
So in your motion, did you just said this wasn't available, is that right? The co-filer, profiler?
There was it wasn't very specific. There was a letter from a DNA expert who had been qualified in Massachusetts and appeared in one case, and that's in my brief. And he had written a letter in response to Mr. Donald's contacting him that there was the profiler plus co-filer test was newer than what was used at trial and was statistically more powerful than what was used at trial.
But you didn't really indicate that it wasn't available at the time of, the trial was in 99, right?
Yes, Your Honor. Yes, I argued that, well, there were the two provisions. Yes, I guess I don't know. I mean, I don't recall specifically. I thought the point of the argument was that it was a newer test and was not used at trial. I don't recall if I said specifically that it had not been developed.
But you do agree that it existed at the time of trial?
I can run through. I think it did exist, Your Honor, and there's a sort of a timeline reflected in the case law on the development of this type of testing. And Mr. Donald's test was conducted by Cellmark in either December 1998 or January 1999. The results were sent to the prosecutor in January of 1999. He was convicted in April of 99. In a case, there's a case, Commonwealth v. Guy, 2009, which says that in May 2000, a main laboratory began using the two newly available kits, Profiler plus Cofiler. So that's May 2000 is a year and a half after Mr. Donald's trial.
But there's actually, I mean, if you went back, there are cases that it's been used before that, I think.
I found several different DNA tests used, and this.
Well, in Colorado versus Schreck, the test used in January of 1999 was the test you're now talking about.
And yes.
And they
that-
said, well, in January of 99, it was relatively new to the market. But that was the test used in January of 1999 by Colorado Labs.
I think, Your Honor, in Schreck, there was that was a published case challenging the admissibility of that. So, and it was being used I believe by the Colorado Labs, but had not been under the standard for admissibility of scientific tests, had not been confirmed to be admissible, and then someone was challenging its admissibility. I think it was found that it was admissible, but that's how new it was at that point.
But it used essentially the same methodology as the DQ alpha test, didn't it?
Well, you know, this is the well, I don't know that, Your Honor. There's a PCR, polymerase chain reaction, which amplifies the DNA sample. So you can do these more sophisticated tests without exhausting the DNA sample, which I understand was true under the old RFLP format. But the fact that it's PCR, and then you've got the different, you could do it under DQ alpha, or that's certain loci, or you can do different testing. It's more loci, and it's different loci.
I mean,
for
your
the
point is
test.
that 13 loci is substantively different than 6.
That's exactly right. I mean, the whole point with DNA is how sophisticated you can make it. So you have. I mean, clearly, if you're looking at something different and you're looking at more loci, and this, I mean, the fact that the patent office allowed this test to be patented, I think it's clearly a different test than was done at trial. And it may have been, the case is referred to as being cutting edge or state of the art or relatively new to the market at about the time Mr. Donald went to trial. So, and then even if you conclude that this test was available at time of trial, then the next question for a hearing would be, was it admissible in the courts of Massachusetts? And we never got to that stage. And I would argue that in this case, all we need to do at the 3B stage is present information demonstrating those factors listed in 3B.
So is your thought that at this point, there needs to be a hearing under 7?
Well, I think at a minimum, yes. I mean,
But I mean, is it also a maximum? I mean, why wouldn't it be a maximum as well?
you mean, why would
Why would we
the
be in a
judge
position to order that the testing be done?
Oh, I see. Well, that's up to you. That's up to this court. I mean, I think that you could find the judge, she denied this. Actually, I think she denied it under, if you found that this was denied under Section 7, which I think you actually could find because of the ruling that the evidence presented at trial, exclusive of the DNA testing, was sufficient to deny Mr. Donald's trial.
Where does that fit into 7?
Well, if you look at, I mean, I don't think it does, but I think if you're looking at Section 7 and looking at this comparison between, well, I guess that would end up back with the judge to reconsider it if you found that she found that although this test was material to identification of the perpetrator, strictly based on looking at the test alone in the context of the facts of the case, it wouldn't make a difference. It was immaterial based on the facts presented at the case. I think if you found that, you would still send it back to her for a hearing. So I guess that's right. It just,
Now, what do you understand the language of the statute to mean? The requested analysis had not yet been developed at the time of the conviction. You speak about admissibility, which I guess is a layering not mentioned in the statute, but
Yeah, it
I mean,
actually
apparently
is.
it was developed.
no, there's
It is
two sections. They're consecutive. The first one says, has it been developed? The second one says, is it admissible in the courts of the Commonwealth?
So in terms of developed, is the patent enough?
I would argue no, Your Honor, on that. I mean, I think even the fact that something's patented, in my brief, I give a brief example of that. The fact that something's patented doesn't mean it's available to the public. So I think just showing something is patented doesn't mean it's available.
So what,
think you would have-
it must be more than developed at the time of the conviction. How do you say we should read that provision?
Develop, well, that's, I think the test would have to be shown to be used in some context or another. It would have to be shown to be a useful test. I mean, if you have something that it's say they use it and it fails, it has a high failure rate, so the test is not as patented. It's not, they patent it for a certain purpose. It's not useful for that purpose. I would say at that point, that test that's been patented is not available to the public. So I think you do have some overlap with the court's consideration of admissibility, just to determine whether or not the test is actually developed, useful, functional, and available to the public. I think you could, have a test that's not not readily available for use by the public, but you could still have it patented in some capacity or another.
Now, by your interpretation of the statute, you hope to be able to get this new profiler, co-filer test. 3 years from now, another test is developed, even better. You can come back and ask for that. 10 years later, a new test, you can ask for that?
Well, I think, Your Honor, under the statute as written, you have to determine whether or not it's material to the identification of the perpetrator of the crime. And if it is, and if it's a new test, and if it meets the other criteria, then I don't see that you can say no. I mean, that's exactly the position we're in now. I mean, I can't predict what will happen in the future. I think 10 years ago, people might have thought that this level of specificity in DNA testing was really a thing of the future, and now it's being used by condominium associations to identify members who don't pick up after their dogs. So it's now it's commonplace, but I think that if something better comes along in the future, meets the requirements of this statute, then you have to allow the test.
Okay, but it sounds as if you're saying, once you get to 1 in a quadrillion, getting to 1 in 10 quadrillion may not be material. That at some point, you don't need new testing because you've already achieved a degree of accuracy and precision where something greater is not likely to be of any consequence.
I think, that's a good point. I think that if you're if you're in the quadrillions, you're clearly, that's not the case here, that
Right, I
you're
know
in the
that.
thousands, but that's an issue I'm really not presented with. And in this case, I think that it's clear that the specificity of the testing under DQ alpha is far exceeded by the discrimination available under the profiler plus co-filer test. Just with regard to the provision that the court can dismiss this under Section 7 if the court finds there's some obstruction or delay. I know this was brought up by Justice Botsford earlier, but I'd like to point out that under the materiality decision is made up front on whether the test is material is made up front in Section 3. And once that is made, then under Section 7, I believe C, the judge, if necessary, can order discovery without consideration of the prima facie requirement of Rule 30. And I would suggest that that provision right there, with the way that's structured, it disallows a judge to balance the evidence, because it would be saying you have to make the decision under Rule 3 that it's material, and then allow discovery, and then once the discovery is made, then you decide the other evidence in the test, other evidence in the case will make that test irrelevant, and that it becomes immaterial. So I think that the way that's worded, I think that the idea of obstruction of justice has to be limited to very, specific findings. I don't know specifically what those would be. The judge made no findings like that in this case. The prosecution's argument was that the defendant was simply trying to obstruct or delay, which I would suggest was probably the same argument we made in many of the cases in which exoneration has been achieved through the Innocence Project.
So what do you think it means?
Well, I think I think maybe it was brought up before, if the defendant's somehow lying or falsifying evidence, something along those lines, I think that you might be able to find obstruction or delay. I also think that, just the fact that it's almost like obstruction or delay implies that you're impinging on the finality interest of the public, which the Commonwealth also raises. And cases have, well, my time's up. Do you mind if I just finish this one point?
Please do.
The case law has talked about finality as being an amalgam of interests, retribution, deterrence, the quality of the judgment, which might become worse over time as memories fade and witnesses are unavailable, and also the interests of the victims. And I would say that if all you're doing here is allowing a DNA test, that none of those interests, with the defendant in jail, retribution and deterrence are achieved. The quality of the judgment is not affected because we're dealing with something that you find under the statute has not degraded, that still has its evidentiary power, and the interests of the victims, there is no interest in incarcerating a person who is innocent. In any case, thank you very much, Your Honors.
Good morning. Good morning. May it please the court. Hallie White Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth. Your Honors, the defendant filed his original motion arguing that he was entitled to testing because the requested test, Profiler plus Co-Filer, had not been developed at the time of conviction. We can argue about what had not yet been developed means. My brother has proposed a number of alternatives, all of which I note involve reading a whole lot of words into the statute that are not there. Whatever had not yet been developed can mean, it cannot mean was used at trials happening before this defendant's conviction, okay? And again, the date benchmark is significant too, because it had not been developed, not at the time of trial, not at the time the original testing was done, not at the time discovery was complete, but at the time of conviction. So April of 1999 is what we're talking about, and there are cases that refer to this test by its commercial name being used at trials in January of 1999.
Okay, so then I take it one would switch to whether it was ineffective. Is that what your argument is, that you would switch to ineffective assistance of counsel?
Well, that has not been raised. That claim that if this test was available...
If it's available, so you would hold this defense attorney to a very strict standard, I take it?
I think it's merely asking him to advance all reasonable grounds for the motion at the time that the motion is filed. We do that in all sorts of contexts, and I don't think it's unreasonable to ask a defendant to advance all possible grounds when the grounds are limited and they're spelled out quite explicitly in the statute, to say, no, it wasn't developed, or if it was developed, then counsel was ineffective. He never did that. He also never made any claim that it wasn't admissible.
That isn't the ground on which the judge denied it anyway.
No.
So let's go to her grounds. Do you think it's permissible to say that the evidence was overwhelming?
That is not the ground on which the motion was denied.
It's one of them.
It is a side note, a comment appended to a ruling affirming and referring to the grounds advanced in the original ruling, which was that the defendant had DNA testing and the results admitted at trial. Now, this may not have the kind of precision that the court would like to see. She didn't say, I find that the test was done, that the test existed, that it was developed.
What do you say was the grounds on which she denied it? He had failed to present information demonstrating that the test had not been developed.
And that's referring to the letter that he wrote?
The letter and the motion.
That's what you say Judge Kottmeyer found?
Yes.
Okay.
What language are you pointing to?
I note that in the appeals court decision, we find that DNA testing was done and the results admitted at trial. Now, that could also be read as ruling that the profiler plus co-filer test is not a new analysis within the meaning of the statute. The basic science underlying it is the same. It operates by PCR amplification and compares alleles at various loci. This one is improved simply because it can compare more loci than the other one.
Do you think that's a good reason to have the testing or not? Or do you think that it would be appropriate to deny the motion because some DNA testing was done, just not this one, where the difference is more than twice as many loci?
The quantitative difference is large. I don't dispute that. I think given the way that analysis is defined in the statute, the process by which a forensic or scientific technique is applied to evidence or biological material to identify the perpetrator of a crime, I think that language suggests that new test not yet developed, means some kind of new scientific principle, which is absent here, and the defendant has made no claim that there is any new scientific principle at work. It's a refinement of the old test.
What do you say to your brother's statement that the letter that the defendant wrote never mentioned a test of any sort?
I think that letter is not a motion.
But the judge,
And if it is a motion, it clearly doesn't meet the requirements of Section 3 because it doesn't include an affidavit attesting to factual, which by the way, he has not provided an affidavit claiming factual innocence. All he says is, I have steadfastly maintained my innocence, which is
so the judge
not the
then
same.
couldn't have treated it as a motion?
She couldn't have, because it doesn't begin to meet the requirements of 3B. So at most, that was sort of dismissed without prejudice. It doesn't matter because at virtually the same time, a motion which does include an affidavit and certainly asserts, makes an assertion for each requirement of Section 3B. And I think one issue before this court is exactly what the threshold showing has to be to get to a hearing. I can't see any reasonable way that we could claim this was denied under Section 7. It was clearly denied under Section 3B. But what is the threshold showing? Is it merely a burden of assertion, even where that assertion, as in the case of test not yet developed, is demonstrably false? Or is it, do you just have to say it? Or do you actually have to make some kind of factual showing? Because the defendant's factual showing here that the test had not been developed, it's the only ground he advances, is false. And just because there is no spaceship out there that uses the curvature of space to get into the cosmos doesn't mean that this test didn't already exist in commercial use at the time of his conviction. Now, briefly as to
Is that your standard?
Excuse me?
In terms of the meaning of being developed, you say the meaning should be in commercial use. You should-
No, I think the patent, I
just-
think the allowance of the patent ought to be sufficient. But
1994,
certainly-
if no test is anywhere, just the patent allowed, you'd say tough luck for you?
I think that means that the test exists. But even if that's
It's
not
not
sufficient.
commercially available?
The statute doesn't say commercially available. If the
What use is
legislature,
it? What use is it? If you can't get it, the fact that there's a patent, what possible use is that?
the legislature knew how to say available if it meant available. But the legislature said not yet developed. And even if this court wants to say we don't think it's just
Any sense?
to say just the allowance of the patent, the test is in use. It's in commercial use. It's commercially available, and not just some test using this technique, but the identical trademark that the defendant is asking for. It's being used at the time of his trial.
So now you've confused me. You say patent is enough, but the fact that it's commercially available matters. Are you saying that if it's not commercially
saying that-
available, it's still developed?
I'm saying the fact that it's commercially available puts us clearly over the not yet developed hurdle.
Okay, and my question to you, is that the appropriate meaning of developed, or are you going to stick with your patent theory? That it may be developed by somebody, but no one really knows about it unless they go through the U.S. Patent Office and checks?
I think that the legislature, we should assume that the legislature meant what it said. And that if the legislature wanted to say was not yet commercially available or was not yet the industry standard, was not yet in common use. And I would also note that under Section 3B5, among the reasons for the test not being done in the ineffective assistance section, does not require the defendant to state that his attorney knew about the test. All that's required is to say he knew that the evidence existed, and that's obviously a matter of the Commonwealth having complied with its discovery requirements, that the evidence existed and that the results of the test could be admissible and relevant. It doesn't actually require the attorney to have known about the test or that this specific test was out there. So I think that what the statute contemplates is new science that creates new possibilities, not merely more sophisticated versions of the old possibilities, including the possibilities not that were available and not used at trial, but used at trial and exploited by the defendant as a strategic and tactical matter. Because what we have in this case is a defense counsel who ably and vigorously and extensively cross-examined the Commonwealth's DNA expert on the number of men in the African-American population that could also have been contributors here. How many of those men live in the Northeast? How many live in the Commonwealth of Massachusetts? And then vigorously pressed this issue, the weakness of the Commonwealth's testing, in closing. He clearly made a strategic decision to rely on what he thought he could convince the jury was the weakness of this scientific evidence as a way of raising reasonable doubt.
Can I ask you this? The analysis that he's requesting, maybe there's a simple answer to this. Was it admissible at the time of trial in Massachusetts?
In Massachusetts, it's not clear. I couldn't find a case that discusses the admissibility of profiler plus co-filer at the time of the defendant's trial. I think had he been the first one to float that in a Daubert-Lanigan hearing, I think it would certainly easily have cleared the hurdle because it's not new science.
When was the first time was it Rozier? Well, there was a case where it was recognized.
Well, it was in the case, I'm just blocking on the name, that where it was tested in the main lab. Guy, is that the one you mean? Guy?
Guy is not, I don't think Guy is about, yes, Guy does mention Profiler Plus.
Tested in
Guy
Maine.
is 2009. I couldn't tell you when the trial was.
Well, it was tested in 2000, and it said it was it was the main laboratory because ours weren't doing it.
Right.
And said it
Which
was
is not required under the statute.
It was a relatively new test.
It was a
at that time.
relatively new test. Had he requested a Daubert-Lanigan hearing, I think he would easily have cleared the hurdle there.
So is that why we would deny it, because he didn't request one?
Because as a strategic matter, he preferred to go with the testing that was done and present that to the jury. And objectively speaking, that was not unreasonable. And as for the overwhelming quality of the evidence, I just want to point out that what we have here is indeed overwhelming evidence.
But just point to me where that matters in this motion.
I think in this particular motion, in this particular case, it is relevant to, it would be relevant to a Section 7 determination.
Where? In Section 7?
To the obstruction or delay element. That where the evidence was overwhelming, the testing would at most reveal a larger...
But on that ground, in almost every case, you could deny the testing, right?
No, I don't think so. I don't think so. Because it's not a question of whether the evidence was sufficient to overcome a required
No,
finding
but I know,
motion.
but a lot of
Obviously-
cases have, I think, as has been argued, there are certainly a number of cases that was available to the legislature, at least as I read, in which you might say the evidence was overwhelming, and yet DNA testing showed that this defendant could not have committed the crime. That was before the legislature at the time, so I don't know whether it's appropriate to be looking at the strength of the case.
I think had the legislature intended that there be absolutely no consideration of the strength of the Commonwealth's case, of the nature, the quantity, the quality of the evidence at trial, of the trial tactics and strategies, they would not have provided that these motions should be heard where possible by the judge who presided at the original trial.
But if a guilty plea does not count,
There's a reason why a guilty plea doesn't count, because courts, and this court is no exception, are concerned about false confessions.
Counsel,
And I think, I'm sorry, my time's up.
well, please finish your thought, though.
My finishing thought is that the fact that the legislature expressly excluded those very narrow items, inculpatory statement to police, guilty plea, plea of nolo contendere, from consideration suggests that other evidence at trial may be in a limited fashion. Nobody is suggesting, despite what the amici argue, nobody is suggesting that the Rule 30 standard applies, and that that kind of weighing happens. But if the legislature had meant this to be as purely mechanical as my brother says it is, any judge could hear it. In fact, you wouldn't even need a judge. It could be heard by a clerk.
Thank you very much.
Thank you.